You do not find out whether your asset protection plan works on the day you sign it. You find out when something goes wrong, a lawsuit, a tax change, a death in the family, an audit. Suddenly, you're making decisions under real pressure, with real stakes, and with no time to fix anything you should have caught years earlier. And here's the problem. Most plans were designed to look protected, not to survive stress. The moment someone with actual training starts digging into it, the cracks show up fast. Commingling accounts, missing documents, rigid trust terms, forced distribution at the worst possible time, entities the client cannot even explain in plain English. And in this video, I'm going to walk you through the exact stress test I run every plan that comes into my office. The questions that reveal where pressure hits first, who controls decision when it matters, and whether your plan would hold up under scrutiny in California courtroom or across the table from an IRS auditor. So you can find the weak points now while you still have the time to fix them. I'm attorney Ali Talai. I am a California asset protection attorney and also an estate planning attorney and founder of Talai Law Offices. In the last video, we covered how sophisticated families actually think about asset protection, the mindset behind layered defense. Today, I want to give you the practical tools to apply that mindset to your own plan. This is also the last video before we go into the offshore asset protection series. Once you finish this, you're going to be ready to work through Cook Islands Trust, Nevis Trust, lease structure, the adaptive trust, equity stripping, multi-jurisdictional planning, and everything in between. Because once you can stress test a plan, you can evaluate any structure on its actual merits, not just on what someone tells you it does. If you want to see how I structure asset protection plans for real estate investors here in California, including LLCs, holding company, Wyoming holding companies, irrevocable trust, layered protection, I walk through all of that in my free asset protection webinar. The link is on this screen and is also in the description below. All right, let me start with the right way to think about this. A stress test is not about proving your plan is perfect. There is no such a thing as a perfect plan. A stress test identifies where your plan would crack under pressure, and pressure shows up in predictable ways. I do this exercise with every new client who walks in to my office with an existing plan. I will be honest with you, roughly 70% of the times we find out at least one significant weakness that nobody really caught before. Not because the original attorney was incompetent, because most plans are designed to be implemented, not to be tested. Here are 7 questions I ask when I evaluate a plan. These are the same questions you should be asking about your own structures right now. The first question is this: if something goes wrong tomorrow, where does pressure hit first? Is it your bank account, your primary residence, a business entity, a trust that automatically pushes assets out to beneficiary? If you cannot answer that question immediately, that is a warning sign. Sophisticated plans are built so that pressure hits buffers, not the people. Multiple layers absorbs the impact before it reaches you. A creditor coming in has to work through entities, charging order protections, trust spendthrift clause, and potentially offshore jurisdiction barriers before getting anywhere near the assets you actually use day to day. That is the layered defense we talked about in the last video. I had a client last year who owned 3 rental properties in Los Angeles County. He had a separate LLC for each one of them. That part was correct, but all 3 LLCs were owned by him personally with no holding company, no trust above them. When a tenant unfortunately filed a personal injury claim, the plaintiff's attorney did not just go after the LLC that owned the property where the accident had happened. They went after the client personally and try to reach the membership interest in all 3 LLCs. If there had been a Wyoming holding LLC and a properly drafted irrevocable trust sitting between him and the property level entities, the pressure would have hit those buffers first. Instead, it hit him directly. The plan had no shock absorber. The second question is, who controls decisions when something unexpected happens? Not who owns the assets, who controls timing, who decides whether money gets distributed or it doesn't, whether an asset gets sold or is held, whether income stays inside the trust or moves out to beneficiary. If control is automatic, forced, or locked in, your plan is rigid. And rigid plans break. A good plan does not predict the future. It preserves your ability to respond to it. So when you're looking at your own structure, ask yourself this. If California raises taxes again next year, can your plan adapt? If one of your children goes through a divorce, would this structure protect their inheritance from the spouse? If you become incapacitated tomorrow, does someone in the trust have the authority to make smart decisions without having to go to court? If the answer to any of those questions is no, or you're not sure, that is a crack in the foundation. Every plan is built on assumptions. Tax laws will not change. Asset values will not skyrocket. Family relationships will stay stable. Nobody will challenge the structure. Stress testing means asking what happens if those assumptions turn out to be wrong. Here's a real example. I reviewed a plan earlier this year for a family in Beverly Hills. The plan was built around an A-B trust structure drafted in 2004. At the time, the federal estate tax exemption was about $1.5 million per person. The A-B split made perfect sense back then. It would have saved the family real money in estate taxes if somebody had passed away. Today, though, with the estate tax exemption at $15 million per person, that same AB trust was no longer saving the family anything. Worse was the fact that B trust, the trust that was created for the deceased spouse, had rental properties that had increased in value immensely. They were not going to get a new step up in basis when the surviving spouse passed away. That plan was built on an assumption about the state tax exemption that had not been true for over a decade. Nobody had revisited. If the answer to what happens when the assumptions are wrong is that the plan still works, that is strength. If the answer is we're stuck, that is exposure. And almost every plan I review has at least one assumption that needs to be revisited. The fourth question is the one that most people avoid. Does your behavior actually match the structure on paper? On paper, are your accounts separate? Are your entities respected? Are the trust roles being followed? Now ask, what is actually happening in real life? Is money moving casually between personal accounts and entity accounts? Are decisions being made informally without written documentations? Are records inconsistent or missing for the last few years? California courts and California agencies do not care what your documents say if your behavior contradicts them. Under the alter ego doctrine, a California court will collapse your LLC if you treated it like an extension of yourself. It does not matter how well the operating agreement was drafted, even if I had drafted that operating agreement. What matters is whether you followed it. The courts look at the unity of the interest and whether enforcing the corporate or LLC veil would create injustice. If your bank account looks like the LLC bank account, if you paid personal expenses from entity accounts, if you never held annual meetings or kept minutes, the entity disappears in litigations. If your plan only works when nobody looks closely, it will not survive when somebody finally does. The fifth test is the one I really like. I call it the stranger test. Would your plan still make sense to a stranger? If you had to explain your structure to a judge, an IRS auditor, or an opposing attorney, could you clearly explain why each entity exists, what purpose each trust serves, how decisions get made and documented? If the best explanation you have is, well, my advisor said this would protect me, that is not defensible, because that advisor is not going to be sitting next to you in the courtroom explaining it for you. Defensible plans are logical, straightforward, and consistent. Every layer has a purpose you can articulate in plain English. Every entity has a reason to exist. Every decision has a paper trail. If you cannot do that right now for your own plan, that is a signal something needs to be simplified, restructured, or properly documented. This connects directly to a concept I'm going to keep coming back to in the offshore series. Optics matter enormously. Every document, every email, every entity name, every business purpose memo gets read by the opposing counsel if you're ever in a litigation. As one of the speakers I heard in a recent offshore planning conference put it, the letter E in the email stands for evidence. Keep this in mind that if a plan looks like an asset protection only, will be attacked as an asset protection only. A plan that looks like estate planning, succession planning, business operation, and asset protection all at once is far more defensible. All right, now let's talk about timing, because this is where a lot of plans quietly fail. Does your plan force action at the worst possible time? Forced sales, forced distributions, forced tax realization. Any plan that forces action during death, lawsuit, market downturn, or family conflict creates pressure, and pressure destroys leverage. Sophisticated plans do it the opposite way. They delay decisions when pressure is high and preserve options when clarity is low. That is not accidental drafting. That is intentional design. A trust that forces a property sale within 3 months of a death creates a fire sale during a market downturn. A trust that gives the trustee discretion to wait until the market recovers preserves value. The difference is one paragraph in the trust language. The financial difference can be millions. The final stress test is the most important one. Can your plan evolve? Not be rewritten from scratch, not require court intervention. Evolve. Can it adapt as law changes, as assets grow, as family circumstances shift, as the federal estate tax exemption change, which it almost certainly will in the next few years? If your plan is frozen in time, it has an expiration date, no matter how good it looked on day one. The world changes, California tax law changes, the federal exemption changes, your family changes. A plan that cannot evolve with those changes is a plan that will eventually fail. So if you take one thing from this video, let it be this. Asset protection is not proven when a plan is signed. It is proven when pressure shows up and the plan still gives you options. If your plan removes options, creates forced decisions, or relies on everything going perfectly, that is not protection. That is exposure waiting to surface. The time to find that out is now, while you still have time to fix it, not when you are standing in the California courtroom or sitting across from an IRS auditor. Now, these stress tests only work if you understand the mindset behind them, because asset protection isn't really about tools or structures. It's about how you think about risk, control, and leverage. In my video, How Sophisticated Families Actually Think About Asset Protection, I walk through the exact mindset shifts that separates families who are truly protected from families who just think they are. That video lays the foundation for everything we covered today, and I would highly recommend watching it if you haven't already done that. Go watch that next video, and I look forward to seeing you over there.